Hi everyone. Um, Firstly, thanks to everyone for joining us today. My name's Phil Gazzola, and I'm joined today by my colleague Nikki Sharp, and we're here today to go through and discuss payments under the Housing Grants Construction and Regeneration Act from 1996, which has subsequently been amended. Hopefully, a lot of the content of today's webinar will be confirming your current knowledge, but even if it just acts as a refresher on some of the issues that do arise during projects, then I think it will probably be a worthwhile exercise. So this, as the slide says, the purpose of today really is to ensure that everyone's got an understanding of the statutory payment provisions, whilst also dealing with and going through some of the relevant case law, which has developed over quite a lot of years, over the last sort of 25 years really. Most of the stuff we're going to cover is more recent than that, but that case law then has established principles about how the courts will deal with issues which come up in front of them in relation to payment disputes. So in the first part of the session, I'll go through the statutory provisions and then cover some of the case law, some of the sort of seminal cases which have augmented and clarified the statutory provisions. And then the second part of the webinar, my colleague Nikki will take over, and she will cover cases, some of the case law which has come up when situations have arisen on projects and there's been problems about or disputes between parties on what the relevant payment terms were or how the payment process should be operated. And obviously no one intends for their project to end up in court, and so the idea really of the second part, at least of the webinar, is to give an idea of how some people have got things wrong in the past, and to hopefully sort of really ram home the importance of making sure that your payment provisions in your contract are compliant with the Act, number one, but also that they're operated properly to make sure that you don't end up in that type of situation. So the first step in the process really in any type of payment dispute is to establish and understand if the Construction Act actually applies to your project. That is the subject of a separate webinar in itself. You could talk about that all day really. So for the purposes of today, we're just going to work on the basis that the contracts we're talking about, that they are construction contracts. If there is an issue on a project that you're working on about whether there is a construction contract or not, very broadly, Section 104 of the Act defines that construction contracts are those contracts for carrying out construction operations. Section 105(1) of the Act then defines construction operations, and that is a fairly wide definition. It can be what you would class as normal building and civil engineering works, alterations, repairs, maintenance, demolition, painting, architectural works, surveying works. Sorry, can we just turn our microphones off, please? Thank you. So then after Section 105 sets out the definition of construction operations, Section 105(2) of the Act then sets out exclusions. The exclusions include drilling and extraction of oil or natural gas, and certain works on sites where the primary activity is nuclear processing, power generation, or water or effluent treatment. As I said, we could spend the whole afternoon dealing with this. So for the purposes of this webinar, we are going to just work on the basis that you've got a construction contract. If that is something that's a problem, our details are on the slides. If you wanted to get in touch and talk through some of those issues, then obviously we'd be more than happy to discuss those with you. But the working on the basis that there is a construction contract, the first relevant part of the Act is Section 109. So the common law position for a construction project is that a contractor isn't entitled to interim payments. They would only be entitled to payment for the work, for the whole of the work when it's complete. So Section 109(1) of the Act rectifies that and provides that unless it's specified or agreed by the parties that the duration of the works is less than 45 days, then the party who's carrying out the works is entitled to be paid by stage payments. And you might say that 45 days never apply, but there are circumstances where if you've got a subcontractor who's doing one element of work, their works could well be less than 45 days, and you could be in a situation where the Act doesn't apply to them. But obviously, that's a fact-sensitive issue. So, Section 109(2) says that the parties are free to agree the amounts of and the intervals at which payments become due. So obviously, the Act is a lot of the provisions of the Act is to give the parties a wide scope to agree things. There's only certain mandatory things that the Act requires your contract to comply with. And Section 109(3) then says, in the absence of a contractual provision to put into place Section 109(1) and Section 109(2), the scheme for construction contracts payment provisions will apply. So that's a separate statutory instrument which sets out a complete set of payment provisions and the necessary parts of it are implied into your contract if your contract doesn't comply with the relevant provisions of the Act. So the next relevant section of the Act is Section 110. So Section 110(1) requires construction contracts to provide an adequate mechanism for determining what payments become due and when, and also to provide a final date for payment for each sum which becomes due. If the parties, so Section 110(1) also says that the parties are free to agree the period between the due date and the final date for payment. Again, this is there's only one time period in the Act which is mandatory. The rest of it, the time periods can be agreed between the parties. So you still see payment terms now where the period between the due date and the final date for payment might be 60 days plus 90 days. I've seen payment terms where it was 120 days. So the Act doesn't say you can't have a long period between the due date and the final date for payment. That's for the parties to agree. But the Act sets other sort of mandatory provisions that have got to be complied with, and then the Act then says at Section 110(3) that if the contract doesn't comply with Section 110(1), the relevant provisions of the scheme will apply. So the next relevant section of the Act is Section 110(a), which deals with payment notices. So and payment notices are those notices which are issued by the paying party or a third party certifier on their behalf. Section 110(a)(1) requires that construction contracts must provide for the payer to provide a payment notice to the payee not later than 5 days after the due date. And that's the only mandatory period that's contained within the Act, is the 5-day period for the provision of a payment notice after the due date. Section 110(a)(2) then says that a notice will comply with this subsection if it sets out the sum that the payer considers to be due at the due date and the basis on which that sum is calculated. If the contract doesn't comply with those provisions, and this runs throughout the provisions we're going to talk about, if the contract doesn't comply with the provisions, the relevant provisions of the scheme will be implied into your contract. So the next section of the Act which is relevant is section 110B, which deals with notices in default. So these are notices that are brought into play if the paying party or their third-party certifier fails to issue the notice that's required of them under section 110A. So section 110B(4), so we'll start at the bottom first, but section 110B(4) says that if the party's contract allows the payee to make an application for payment effectively, and the payee does so in accordance with the terms of the contract, that application for payment will constitute the payee's notice in default. So if you're a party seeking payment, you issue an application for payment, and you do so in accordance with the contract, that will constitute the payee's notice in default. Moving back, section 110B(2) says that if your relevant contract doesn't allow for the payee to make an application for payment, the payee can submit an application, a payment notice in default, any time after the date on which the payment notice was required. So the 5-day period after the due date when a payment notice should be issued, if no payment notice is issued and your contract doesn't allow for applications for payment, then the payee can issue a payee notice in default anytime the day after the 5-day period expires. And what the Act says is that if you issue a notice in default in accordance with section 110B(2), the number of days after the date when the payment notice was required, the final date for payment will be delayed by the same number of days. So if the payment notice was required on a Monday and the payer or the third party certified don't issue one, and you issue your payment notice in default on the Tuesday, the final date for payment will be delayed by 1 day. If you issued it the following Monday, so 7 days later, obviously I'm not dealing with bank holidays or anything like that, but if you issued it 7 days later, then the final date for payment will be delayed by 7 days. And obviously then that pushes out the date for when a pay less notice, for example, might be required, which we'll move on to in a second. So section 111 of the Act requires the paying party to pay the notified sum on or before the final date for payment. And section 111(12) defines the notified sum as either payment notice issued by the paying party, an application for payments, which would constitute a payee notice in default, or a payee payment notice in default, which is issued after when the payment notice was required of the paying party. Section 111 then goes on to say, and it provides the only situation in which the paying party can pay less than the notified sum. So to pay less than the notified sum, the paying party must issue a notice of its intention to pay less than the notified sum on or before the specified number of days before the final date for payment. Any notice that's issued as a pay less notice must set out the sum the payer considered to be due on the date of the notice, rather than the due date, which is when the payment what the payment notice should set out, and must also provide the basis for calculation of that sum. The period for when the pay less notice is to be provided, again, that's open to the parties to negotiate, and quite often you'll see the period will be 1 day before the final date for payment. The pay less notice will be required. It just depends on the parties' contract. One thing the Act makes clear though is that you can't issue a pay less notice before the notified sum is established, which has happened in a number of cases. But that's what the Act says. So now we'll move on to look at a couple of the cases which have really helped to clarify and define exactly what is required of the relevant notices in a payment cycle. So this is the first case we'll talk about. So it's Caledonian Modular versus Mars City Developments, and Mr. Justice Coulson at the time said that that's one of the paragraphs from his judgment, and basically the idea is if a contractor or a party seeking payment, so it might be a subcontractor or whoever it is, a party seeking payment wants to rely on the failure of the paying party to provide notices, then they must have complied with their obligations under the contract. And what he said is they must have been given reasonable notice that the payment period has been triggered in the first place. You do see situations where parties might try and there's been quite a lot of the cases are dealing with situations when parties try and maybe get an application in under the radar, maybe, to try and engineer a default payment situation potentially. Whether it's engineered deliberately to seek that to end up in that situation, or that's just how it's happened and it has resulted in a default payment situation. It just depends on the scenario. But the courts are pretty clear that if you're seeking to rely on the failure of the paying party to provide the relevant notices, you must have done what you're obliged to do under the contract as well. There's a subsequent case of Henia versus Beck, where the court established, and this was taken from the Act and then some previous case law, that in order for an application for payment, and this is dealing with applications for payments from a payee, in order for an application for payment to be valid, and so to potentially stand as a default payment notice in the event of a failure to provide a payment notice by the paying party, then it's got to set out the sum due, by the basis on which the sum claimed is calculated, be given in accordance with the contract. So those first three provisions really are taken from the Act, and then the case law has established that it must be in the relevant notice must be in substance, form, and intent, an interim application, and it must be free from ambiguity. So essentially, it must be clear to the party who, when you're making the application for payment, it must be clear to the paying party that that is what it is. It's an application for payment, rather than an interim assessment or a draft final account or something like that. It's got to be clear on the face of the document and within the document that it is an interim application for payment. So, Henia versus Beck also discussed the requirements for the content of pay less notices, and Mr. Justice Aikenhead said that one way of testing the validity or otherwise of the pay less notice was to see whether it provided an adequate agenda for an adjudication as to the true value of the works and the validity of the alleged entitlement to liquidated damages for delay. So essentially, is it possible to ascertain the relevant party's assessment of the true value of the works from the content of the relevant notice? If you've got, in an application for payment, you've got a load of items, and then in the pay less notice or the payment notice, it just says on account against all of them, £10,000 or something like that. There's a real question whether that would set an adequate, that would give an adequate agenda for an adjudication. So that's what that's how the case law is developing, really, or has developed. So the subsequent case of Grove Developments versus S&T, the court said that effectively there've been some cases before where it talked about there potentially being a different approach between the different type of notices and whether one might be considered more leniently by the courts than another. And the TCC said the courts won't adopt a different approach to when it comes to construction of the different types of notices. And referring to the previous case law, which had dealt with the requirements for applications for payment. Mr. Justice Coulson said, in my view, that general guidance applies equally to a payment notice and a pay less notice. So the criteria that we set out a couple of slides ago in relation to an application for payment, that it's the same criteria will be applied to when the courts will decide whether a payment notice or payment notice in default or a pay less notice is valid or not. So, and the court went on to set out those requirements and just repeat really what had previously been said in previous case law. So each notice must make it plain that it is a payment notice or pay less notice, clearly set out the sum due or the sum to be deducted in the case of a pay less notice, provide the basis on which that sum is calculated, and beyond that, whether or not it's a valid notice in accordance with the contract is a matter of fact and degree. So obviously not every contract is different, but the vast majority of contracts on different projects, there will be amendments, and so each contract that's being worked on, there's a good chance there will be different. You quite rarely now see unamended contracts. More likely probably to see unamended NEC contracts, but even then, most projects have Z clauses now. So the payment terms quite often are one of the things that are amended, and the payment terms might impose additional requirements for the provision of applications for payment, for example, where it might require certain information to be provided along with the application for payment, or for the application for payment to be provided in a particular format. And whatever one of the key characteristics that the court will look at in relation to an application for payment, and then the other notices as well, is whether it complies with the contract. So if your contract says your application for payment should be provided in a particular format or with particular information along with it, they're provisions that you must comply with if you subsequently then want to rely on your application for payment as a potential default payment notice. So that's just a quick run through of some of the three of the sort of really seminal cases on that have clarified the Construction Act, or the provisions of the Construction Act in relation to payment. So I'm going to hand you over to Nikki now, and she's going to then look at some of the case law when the courts have had to deal with problems or issues arising in payment cycles.
Thank you, Phil. Good afternoon, everyone. I'm obviously going to take you through some of the case law regarding default payment situation. However, before I discuss the case law, I just want to run through some basic points. So what does a default payment situation actually mean? Well, as you can see on the screen there, it's where the payer is under an obligation to pay the full amount of the payee's application for payment, regardless of any defences and counterclaims that the payer may have. So just to give you a summary, a default payment situation will arise when the payee is issued a valid application for payment or a valid default payment notice. The payer has failed to issue a valid payment notice or a valid pay less notice. The final date for payment has passed and the full amount of the notified sum has not been paid. Now, there is a concern that this can arise as a default payment situation can also arise where there's been a negative valuation. So, for example, if you receive a payment certificate that has a negative value, so a minus, then there is a suggestion that a pay less notice should be issued in response to that. If anyone has any questions to that, please feel free to ask and I can answer that at the end. So just moving on. So do smash and grab or default payment situations exist? Well, large numbers of smash and grab adjudications have always been commenced. However, the cases in the courts highlight some of the difficulties that parties will face when they pursue monies by way of a technicality. And that's because there are increasingly more factors that need to be considered in order to conclude that a default payment situation has actually arisen. There is also obviously the risk of a smash and grab adjudication, and that is that a party is seeking to recover more monies than it's actually properly due and owing, in the event that obviously the true value of the works had been assessed. And you'll see in these cases that the amount that's the default payment, the notified sum, is usually extremely significant. So let's start working through some of the cases now. So looking at this first case, systems pipework and rotaries rebuilding services. So just give you a brief summary of the background facts. On the 2nd of September 2016, the contractor provided the subcontractor with a lengthy document, which was described in the covering letter as our final account assessment for the works carried out on the above project by your company. And the issue in this case was whether the document sent by the contractor amounted to a proper notification of the amount due for payment in respect of the final accounts. The court held that the contractor's document of the 2nd of September did not constitute a valid payment notice. And there was a number of reasons for that, so I'll just go through them quickly. First, neither the letter nor the documents said that it was a notification of the amount due. Neither the letter nor the attachment contained any identification of a particular sum which was said to be due and payable. Third, nowhere in the documents was there a reference to the final account clause, which was clause 28.6. And the court actually said that if a notice under a certain clause is to have draconian consequences pursuant to the contract, then the notice should make clear it's been issued under that clause. The fourth reason, that it was clear from the contractor's own evidence that the documents were not the notification of an amount due. So as a matter of substance, the attachments were plainly a valuation of the whole of the subcontract works with no actual identification of any balance due. Sums previously paid, retention and alike were actually nowhere to be found in the documents. So the court said that it was not a reasonable recipient would not have been able to calculate the sum due and would not have regarded the document as a notification of the sum due. Going on to the next case here, on this one, the employer issued a pay less notice and had specified the sum due as 0. One of the issues was whether the pay less notice was valid. The contractor argued that it was not valid because it didn't provide a basis for the 0 sum figure. The court held that the reasonable recipient could not work out the basis on which the sum had been calculated. And what the court said is that the pay less notice needed to set out the grounds for the withholding, the sum applied to each ground, and the calculation thereof. And because it didn't do so, there was no basis for the 0 sum figure. So the court held that the pay less notice was not valid. So the lesson to be learned here is simply to, if you are going to give a payment notice or a pay less notice, you need to establish each ground and you need to say the amount that's attributable to each ground, so that for example, the contractor in this case would have been able to work out the basis upon which the 0 sum had been calculated. So moving on to the next case, which is Joraby, the contract required the contractor to make interim applications for payments on the 8th day of each month. On the 5th of January, the employer actually emailed the contractor asking for them to submit their application tomorrow, so i.e. on the 6th of January. Now, the contractor didn't submit its application on the 6th of January. It actually submitted an initial assessment on the 7th of January, and that initial assessment was for the total gross sum of 2.35 million. Now, there were errors in the summary sheet which were attached to the application. For example, the summary referred to the gross total due for valuation 6 when it was in fact valuation number 7. And it also referred to valuation of the works up to the 5th of January in one place, and in another place it valued the works up to the 7th of January. Now, the employer issued a payment notice on the 15th of January, so it was therefore late under the contract and the Act, and the employer did not issue a pay less notice. So the question here was, could the contractor rely upon its application and claim the full amount in that application as the amount due to it? Now, the court found that the application did not comply with the contract, and the presentation of the application didn't actually follow the pattern that had been established in relation to previous applications for payment. And there were a number of reasons for this. So first of all, it was issued in response to a request from the employer to provide the valuation the next day, and that deadline had not been met. It described the application as an initial assessment. The court said this made it clear that it was not firm or their final assessment, and so it couldn't be objectively construed as a statement of what the contractor believed was actually the amount due on the due date. Obviously, there was the confusion around whether it was valuation 6 or 7 and the date upon which the works had been valued up to. And this valuation, unlike all the previous valuations, it didn't actually go up to and include the due date for payment, which in this case was actually the 8th of January. So the court therefore found that it could not be said that the application was free from ambiguity, and therefore it found it to be invalid. This case obviously highlights the importance of clarity in making applications for payment. And as Phil has already said, ensuring that the application is in substance, form and intent clear and unambiguous, and that it contains all the requisite information required by the contract. Moving on to the next case, which is Grove and Balfour Beatty, you'll see on the screen that we have a payment schedule there. The contract between Grove and Balfour Beatty included that payment schedule, which provided for payments in accordance with the schedule. And I don't know whether you can actually see on the screen there, the last few entries in the schedule were valuation number 21, 22 and 23. Now, following 23, there were no other entries, and there was nothing to suggest that if the works continued beyond July 2015, that applications could be made beyond that date. Now, Balfour Beatty, despite the fact that there was no line in the payment schedule, Balfour Beatty submitted its application for payment 24 on the 21st of August 2015. Grove did not pay, and Balfour Beatty adjudicated and went to the TCC for payment. The Court of Appeal agreed with the TCC judgment that because the contract didn't provide a mechanism for future payments past the latest date in the payment schedule, no payments were due past that date until the final account procedure. So therefore, the Court of Appeal decided there that there was no entitlement to payment beyond payment 23. What the court did say is that the parties are free to agree payment terms, and Balfour Beatty could have negotiated terms given the right to payment beyond application 23, but did not do so. And moving on to the next slide, again, this is a payment schedule. You'll see from this schedule that the applications 1 to 7 were all the same. The assessment date was the 2nd of the month. The due date was 14 days after the assessment date. The date for the payment notice was 5 days after the due date. The final date for payment was 21 days after the assessment date. And the pay less notice was required not later than 2 days before the final date for payment. I understand that this may be breaking up. Phil, can you hear me?
I can hear you fine, yeah.
Okay, great, thank you. However, for application 8, the schedule showed the due date as the 18th of November 2021, with the payment notice date as the 23rd of November and the pay less notice date as the 21st of November. The main contractor issued its payment notice for application 8 on the 23rd of November. That was in accordance with the schedule. The court decided that the payment mechanism in relation to application number 8 was in contravention with the Act, and that was for 2 reasons. Firstly, the date for the payment notice was more than 5 days after the due date, which is not allowed in accordance with section 110A, subsection 1A of the Act. And also, the date for the pay less notice predated the date for the payment notice, which again was not allowed in relation in accordance with section 111, subsection 5B of the Act. However, the court took a pragmatic approach here and decided that the reference to the 23rd of November in the payment schedule was clearly a mistake and that it was actually intended to be the 21st of November. However, as the payment notice had been issued on the 23rd of November, that is 2 days too late, the court held that it was not a valid payment notice and it couldn't actually be a valid pay less notice because the pay less notice was the 21st of November also. So the subcontractor in this case was actually entitled to the full amount of his application for payment. And that brings me to the end of the slides. So if anybody has any questions that we can go to, and we can answer those for you. I think one person's got their hands up. Lindsay? Does Lindsay have a question? Does anyone else have any questions for Phil or I? Oh, I don't think Lindsay could actually hear what I was saying.
Nothing in the chat, is there? No, there's no questions in it. No questions in the chat. So if there's a message. Yeah, if you can either just put your hand up and ask us, or put something in the chat function, whichever's easiest, whatever you prefer.
I don't think we have any questions.
I've got a hand up there.
Hi there. Yeah, I don't have a question actually, but it's just thanks really. I found that really useful and informative. There's quite a few points you raised there that clarify some of my own understanding. So yeah, thank you. It's really useful.
Good. Glad it's been useful. The thing, you know, these type of things, and I think Nikki would confirm this. You know, these type of things do come up all the time, and I think it is quite useful to sometimes just, even if you know, people know the way around the Act pretty well, it's useful just to have sometimes to have a refresher as well, just to, you know, clarify a few things and hopefully make it clear in your mind what the obligations are. So I'm glad it was useful. If no one has got any other questions, then I think we'll probably leave it there, unless anyone else has got anything. Okay. Well, you can get a copy of the slides from our website. That's obviously on the slide there. And if you need anything, or you wanted to get in touch, then you know, get in touch with Nikki or myself on our email addresses, which are on the front of the first slide, or you know, LinkedIn or whichever. And if we can help you, then we will. If I think a recording of this gets put on the PIG website and on YouTube. So again, if you needed to come back and have a look, just a reminder of any of the issues, then obviously you'd be more than welcome to. So yeah, just thanks for your time and thanks for listening, and hopefully it has been useful.